Good morning, everyone, and welcome to the Employment Law Update. I'm Michael, and I'll be covering some of the issues today, and my colleague Bob will um, also be involved. Today we're going to be talking about the Employment Bill. The invitation to this event referenced a case law review, but we've decided to put that off to another session, given how much there is to discuss in the new bill. The bill implements many of the proposals in Labour's plan to make work pay, although not all of them. So single worker status, changes to TUPE, and consultations on parental leave. Those issues will be looked at once the bill is passed. The stated aim of the bill is to assist in achieving the government's aim of ensuring that the economy works for working people. The reforms are intended to raise the floor and end the race to the bottom that saw some compete based on low pay, low standards, and insecurity. And I'm quoting from the government's documents there. So whatever your political outlook, the bill contains a radical set of reforms. It's worth mentioning at the outset that much of the detail behind the reforms we worked out in future regulations and consultation, and that nothing will be coming into force overnight. The bill is unlikely to become law until mid-2025, with many of the rights not coming into force before 2026. So looking at the overview, I'm going to be dealing with day one unfair dismissal rights, fire and rehire, and flexible working. And Bob is going to look at zero-hour contracts, sexual harassment, and unions and consultation, and finish off with the what happens next slide. So moving on to the first slide regarding unfair dismissal. In opposition, the government committed to making unfair dismissal a day one right, whilst also permitting probationary periods with fair and transparent rules and processes. There's an obvious tension between these two goals, and the bill goes some way to explaining how this tension will be resolved. However, a lot of the detail is yet to be sorted out. Making unfair dismissal a day one right is pretty straightforward. The government has simply removed the 2-year qualifying period from the legislation. Permitting meaningful probationary periods is a bit more difficult. The first thing the government has done is allow for a new initial period of employment, during which it will be easier to dismiss an employee fairly. What the government says in its next steps document is that fair dismissal will not be prevented, and the bill allows employers to operate probationary periods by providing an initial period during which there will be a lighter touch process for employers to follow to dismiss an employee who is not right for the job. So how long will that initial period be? Well, that's not clear at the moment, and it's something which is subject to consultation over the coming months. The government's stated preferred option at the moment is a 9-month statutory probationary period. So what will the light touch process look like? Again, that is to be confirmed in regulations and consultation. It's likely there'll be an obligation to hold a meeting to discuss the concerns the employer has about the employee, and the employee will have the right to be accompanied at that meeting by a trade union official or work colleague. To benefit from the protection offered by the light touch process, the dismissal will have to be for performance, capability, illegality, or some other substantial reason relating to the employee. Now that means that unfair dismissal is a genuine day one right, where the reason for dismissal is either redundancy or some other substantial reason relating to the needs of the business as a whole, rather than relating to the employee. What this means is that tribunals will look into the reason for a dismissal during the statutory probation period, as well as checking that the light touch process has been followed. How far an employer will need to go to establish the reason for dismissal is not yet clear. In its next steps document, the government also says it will consult on a compensation regime which will apply during the light touch procedure. It seems that some form of limited compensation will apply during the statutory probationary period to help reduce the cost burden for employers. But again, that detail will come out over the coming months in consultation. In terms of timing, the government has committed to full consultation and a substantial period of transition, meaning that the new rules will not come into force until the autumn of 2026 at the earliest. So moving on to the next slide, fire and rehire. This has been a hot topic over recent years, as I'm sure you're all aware, especially in light of several high-profile cases where employers have sought to use fire and rehire tactics to alter employment terms or replace one type of employee with another, particularly the P&O case, where domestic workers were replaced with overseas workers who were paid significantly less and employed through intermediaries. Under the bill, fire and rehire and fire and replace will not be completely banned, but they will be heavily restricted. Employers will no longer be able to use these methods to dismiss without facing a high level of risk of unfair dismissal claims. Specifically, dismissals will be automatically unfair if the reason or the principal reason for the dismissal is either that the employee did not agree to the employer's attempt to vary their terms and conditions, or that the employer intended to hire someone else on different terms to perform the same role. This is a major shift from the current legal framework, which allows employers to justify fire and rehire and fire and replace on the basis of a sound business reason. The bill introduces a limited exception where fire and rehire and fire and replace will still be lawful if the employer can demonstrate that the dismissal is necessary due to financial difficulties that threaten the viability of the business. In this context, the employer must also show that no reasonable alternatives are available. This test sets a very high bar for employers. Under the bill, employers will need to show evidence that they are in genuine financial difficulty and that fire and rehire or fire and replace is the only viable option to keep the business afloat. Additionally, the government intends to consult on lifting the 90-day pay cap for protective awards in cases where collective redundancy processes have been engaged. Whilst the reason for implementing the change is to stop what the government sees as unscrupulous practices, the way the bill is written means that it could have more wide-ranging impacts. It appears to impact on any attempt by an employer to vary terms and conditions of employment, even for a single employee. It is also not clear how the provisions will interact with some redundancy processes or business reorganisations that offer redeployment as an alternative to dismissal. It is difficult to see what all this will mean in practice, but one obvious outcome may be the use by employers of contractual variation clauses in contracts of employment. The use of such clauses has traditionally been difficult, and it will be interesting to see if tribunals change their approach in light of the restrictions in the bill. Moving on to the next slide, which is regarding flexible working. This area of employment law has been evolving, especially post-pandemic, and the bill makes it even more challenging for employers to refuse flexible working requests. Under the bill, employees will continue to have a statutory right to request flexible working from day one, as they have now. Employers will also be able to rely on the same statutory grounds that they have now. However, there will be a new obligation on the employer to show that its refusal is reasonable. The new requirement of reasonableness will likely introduce a much higher threshold for employers. Whilst it's not clear at the moment how the test will work, tribunals will scrutinise a refusal in a different way, looking at questions of reasonableness as well as procedural compliance. In addition, the bill also includes a power for future regulations to specify the steps employers must take in consulting with staff before refusing a flexible working request. And there's also likely to be a statutory duty on the employer to explain in writing why it considered any refusal reasonable. In practice, this means that employers will need to be more thorough in the way that they assess flexible working requests and have clear objective evidence to establish the reasonableness of their actions. So moving on to the next slide, and my colleague Bob will be taking you on from there.
Thanks, Michael. Good morning, everyone. I'm Bob Fay, and as Michael said, I'm going to be covering the proposed changes to zero-hours contracts, the prevention of harassment duty, and a couple of changes relating to trade unions and collective consultation. And I'll start here with the proposed changes to zero-hours contracts. Um, and as Michael has said, the bill does set out essentially something of a framework and leaves quite a lot of the details of the proposed changes to regulations. And this is definitely one of those areas where that's the case. In relation to zero-hours contracts, the proposal is to introduce significant reforms with the aim of providing greater security for workers who are carrying out zero hours or similar contracts. And if implemented in their proposed form, it is likely the changes will significantly shift the balance of flexibility towards employees and limit the abilities of employers to use these contracts as freely as they do now. Um, you'll see the key points are set out on the slide, and in many ways, there's not a great deal to add to what's there in the bullet points. But just to cover in a bit more detail, under the bill, employers are going to be required to offer zero-hours workers a guaranteed hours contracts at the end of every reference period. Now, the length of this reference period and quite a lot of the other key details are going to be set out in regulations. So we don't know how long a reference period is going to be. But after a certain period of time, employers will need to offer workers more stability in terms of hours. What they will have to offer will need to specify either the days of the week or the hours the workers will be offered, or a working pattern that reflects their actual hours worked during the reference period. Already you can see, even without details, there's potential scope there for quite difficult situations where, for instance, you have an employee who's working during a particularly busy period and therefore working hours that are out of proportion to those that would normally be required. And that's the reference period that then is used to fix the guaranteed hours that the employer is required to work, for instance. So that's going to be a significant change to the current position. Um, the bill also includes a mechanism for termination in cases where the work ceases or diminishes, or where you have a fair reason for dismissal under Section 98. So one of the 5 existing statutory fair reasons to dismiss. And so this should allow employers some flexibility to terminate contracts if they genuinely no longer need the work for a certain period. But it does introduce additional obligations to offer a guaranteed contract while the work is ongoing. Another significant change is that reasonable notice of shifts is going to be required. So employers will need to provide reasonable notice of when the employee is required to work and when a shift is cancelled. And again, what constitutes reasonable notice is going to be determined by regulations, so we have no details on that yet. I could imagine that it might be at a minimum an equivalent to, say, the regime for statutory annual leave at the moment, where in order to give notice of a rejection of a request for annual leave, first of all, the employee has to give as much notice of the period of leave, and then the employer has to respond within that period. So if, say, a shift is an 8-hour shift, would something in excess of 8 hours notice be required? I could see that being a reasonable minimum. This is conjecture, we don't have any actual detail yet. And then for short notice cancellations, so whatever the reasonable notice period ends up being, if you fall short of it, employers will likely need to pay the worker for the cancelled shift to ensure the workers are not penalised for having their shifts cut without adequate notice. So essentially, the potential for financial penalties for employers who rely on fluctuating demand and last-minute scheduling. Yeah, the devil will, of course, be in the detail, but a significant change in position. If we move to the next slide, please. Now, the slide says sexual harassment, but in fact, one of the most significant changes being introduced is that the new duties will not relate to sexual harassment alone. So there's a slight error in the title of the slide. It's worth, I think, reminding us all that there has been a very recent development in the law on sexual harassment, and it is still the case that with effect from the 26th of October, so 10 days' time, the Worker Protection Amendment of Equality Act introduces the new sections into the Equality Act that place employers under a duty to take reasonable steps to prevent the sexual harassment of their employees. And the consequences of a failure to do so could be that if an employee succeeds in a harassment claim in the tribunal and the employer is found to be in breach of the duty, then there could be an uplift of up to 25% of compensation to reflect that breach of duty. And the Equality and Human Rights Commission is also able to take direct enforcement action against employers who breach the duty. So that's not part of the new bill. That's the reform introduced by the previous government, and that's still coming into force in 10 days' time. One of the reasons I think it's worth reminding you of this is that the EHRC, the Equality and Human Rights Commission, has published its technical guide and an 8-step guide for employers on preventing sexual harassment at work. And that sets out 8 steps, not as an exhaustive list, but in order to help employers take positive action to prevent and deal with sexual harassment in the workplace by implementing those steps. And the 8 steps, I'm just going to list them quickly. They are, and it should be said, largely self-evident and relatively straightforward, but the 8 steps are: develop an effective anti-harassment policy, engage your staff, assess and take steps to reduce risk in your workplace, report on the action you take, train your staff, address how to react when a harassment complaint is made, deal with harassment by third parties, and monitor and evaluate your actions. Now, the reason I've taken the time just to remind us all of the position as it's going to be shortly will become clear when we get on to the new duty. So the new reasonable steps duty, as the slide says, will become an all reasonable steps duty, which is the language that was originally proposed in relation to the new prevent duty that's coming into force. And as it says on the slide, express protection against third-party harassment will be introduced. And as I mentioned before, this will relate to all harassment and not just sexual harassment. Now, we don't yet know, we don't yet have any guidance as to what reasonable steps employers would be required to make would be, and regulations are going to be brought forth to set out more information on that. But I think it's highly likely that an employer that doesn't at least implement all 8 of the EHRC's proposed steps, which related to a lesser duty merely to take reasonable steps rather than to take all reasonable steps, is, I think, very unlikely to be able to satisfy the new duty. So any work you have been doing to implement compliance with the EHRC's guidance at the moment is going to stand you in good stead in the long term. And the final point on the slide, sexual harassment disclosures are going to be made as qualifying disclosures under the protected disclosure regime for whistleblowing. It's already being said by a number of commentators, and I think this is right, that it is highly likely that a disclosure of sexual harassment in the workplace would already have amounted to a sexual disclosure, to a protected disclosure within one of the other categories of protected disclosure in existing legislation. So I think we can regard this as an amendment aimed at emphasizing the importance of allowing staff to report on such allegations without adverse consequences, rather than a significant change in the employer's duty where such a disclosure is made. I think that's probably all I will say for now on the all reasonable steps duty. But of course, if you've got any questions, Michael and I want to leave as much time as possible for questions, because we think there's probably going to be quite a lot. So if we go to the next slide, please, and my final topic, the unions and consultation. And these are two separate topics really, but we've grouped them together given the collective element that applies to them. Now, the first change will be the removal of the requirement for a single establishment rule when determining whether the duty to collectively consult is triggered. You may remember that there was significant legislation, litigation rather, around the administrations of Woolworths and the Ethel Austin chain that went as far as the European Court of Justice on whether the UK's requirement for the 20 or more redundancies within a 90-day period needed to be at a single establishment or not in order to trigger the collective consultation obligation. And the outcome ultimately of that litigation was that it was upheld that the 20 employee limit had to be reached within a single establishment, and therefore many of the different Woolworth branches, for instance, fell outside the duty to collectively consult because in the single branch, which was determined to be an establishment, they didn't have 20 or more employees who were affected. So this proposal is effectively a statutory way of reversing that decision. And if you have multiple sites, multiple establishments, you will need to aggregate the number of employees affected across them when considering whether your collective consultation duty will be triggered. The second bullet point refers to a number of changes, all of which are aimed at making it easier for unions to access workplaces and streamline the process for unions to become recognised as representatives of the workforce. So with these proposals, unions would gain a right to request access, and in response, employers could either choose to negotiate the terms of legally enforceable access agreements, which is a new concept brought in the bill, or the union would be able to apply to the CAC, the Central Arbitration Committee, which is the body that deals with formal recognition of unions. And the CAC would have the ability to order access, and there would be a presumption that union officials should be able to access a workforce in any manner that does not unreasonably interfere with the employer's business. Now, there aren't at the moment any default terms set out for the access arrangements where the parties are unable to reach agreement through negotiation, but those it is intended will be prescribed in future regulations. Next slide, please. So that's an absolute whistle-stop tour of the key points. What happens next? The bill will now undergo parliamentary scrutiny before being passed as an act. Its readings are taking place in the Commons at the moment. The second reading is scheduled for the 21st of October 2024, so it's going to be debated in the Commons and Lords before it can be passed into law. Obviously, a lot of the detail is going to be left to secondary legislation, so that means that even after the bill is passed, we're going to need to wait for statutory instruments to be created to clarify exactly how these changes are going to be implemented, and a lot of the detail around, for instance, probationary periods, 0 hours contracts, fire and rehire rules, and so on. And these are all going to be subject to consultation of future regulations. In the next steps document, the government has outlined a timetable with consultations planned for 2025. So even after the bill passes, there will be a period of discussion and consultation with stakeholders to shape those final regulations and much of the details that we don't yet have. And as Michael said, most of the major reforms are expected to come into force no earlier than, we think, the autumn, in fact, of 2026. So before we take questions, we've just been asked to let you know, if we go to the next slide, please, about some of the training that VWV provides as an e-learning solution, HR and employment law for line managers. Given how much the employment legislative, how it's easy for you to say, legislative scene is going to change over the next couple of years, keeping your line managers up to date with key legal areas is going to be remain at the top of people's agendas. And in order to help you do that, we've got these 9 short courses covering the key legal areas that are set out on the slide. And I think we have a little poll for you for a bit of audience participation. So if any of you would like to contact you with further details on the e-learning series, please do tick the appropriate box. And you've got a couple of other options there to say maybe later or politely decline. So we'll give you a minute to run through those. And then hopefully we'll have, I can see we do have quite a few questions in the Q&A. So while you're answering the poll, if Mike would like to come back on the screen, and then he and I can run through your questions and try to answer as many of them as we can.
So shall I start off there, Bob?
Yeah, thanks, Michael.
So the first question is the 2-year qualifying period removed as of now? And the answer to that is no. It's going to be removed formally in the autumn of 2026, subject to consultation, obviously, and what comes out of that. But I suppose the practical impact is an interesting one, that autumn of 2026 is 2 years away. So if you're hiring now, it is possible that the period, the qualifying period, is in effect gradually diminishing, because if you hire someone in 6 months' time, there will only be 18 months before the law changes. So there is a practical impact as of now, even though the change itself is some way away. And of course, we don't know exactly how the change will be implemented, whether there'll be any transitional provisions or how it will apply. But I guess we need to start thinking about it now, given the fact that the 2 years is diminishing, or the 2 years before the autumn of 2026 is diminishing. I don't know if you have anything to add to that, Bob, or should we just move on to the next one?
Yeah, I think so.
The next one is, when do we expect day one sickness pay to come into effect? And I think the answer to that is we don't know, but the new steps, the next steps document says that the government is seeking input from stakeholders and anticipates that this meaning that the majority of reforms will take effect no earlier than 2026. And then it goes on to say that reforms to unfair dismissal will happen no sooner than the autumn of 2026. So I guess we could take from that that the sickness pay changes will happen in 2026, but we don't know when.
Yes, I think that's right. And I think that probably answers the next question as well, which is what is the consultation time for the fire rehire regs? So as I said in my closing slide, and you might have asked this question before we got there, but first we've got the bill itself that's got to go through Parliament, and then once the bill's published during 2025, there's going to be consultation with what the government describes as key stakeholders regarding the actual details in any regulations. So yeah, throughout that period, we think.
I suppose the question might mean as well, what's the consultation time before you're allowed to fire and rehire?
Oh, right, yeah.
Potentially.
Well, yes, okay.
And if we look at it that way, the answer is there is no set time in the legislation. I guess that guidance may come out in due course. There is also some guidance in existence about fire and rehire. But I don't think there'll be a statutory period over which consultation needs to happen. I suspect it will be that fire and rehire is a last resort, that you need to have exhausted all alternatives. And there is that only going to be a specific exemption, which I talked about in the slides, around genuine financial difficulty. But if you're in that exemption, you will still have had to consult fully, I think, to show that no alternatives to fire and rehire or fire and replace were available. So I suspect this will be a matter for guidance, and it'll be a case-by-case basis rather than a statutory consultation period. So the next one, Bob, maybe in relation to something you were covering, is there a minimum guaranteed amount of hours that we can offer workers on 0-hour contracts?
Yeah, and I think the real answer to that has to be we don't know yet. And until the actual regulations are put forth giving the details around what an employer is required to offer, we won't have the answer. But the actual, I just had a quick look at the actual bill itself, And the bill specifically inserts into existing legislation the words or similar after 0 hours contracts, 0 hours contracts or similar. And the reason behind that is to prevent employers seeking to rely on a loophole of offering a small amount of minimum guaranteed hours to avoid the intended effect of the 0 hours contract changes, which at the end of the day are aimed at reducing employers' flexibility and giving employees a greater degree of certainty about their hours. So I think what we'd have to say is we can't rule out the possibility that something will be achievable in that respect. But it's likely to be a relatively significant number given that the underlying purpose is to reduce employer flexibility and give employees more certainty in exchange. I think the next one is mine as well, Michael, which says, regarding 0 hours contracts, if the work is seasonal, could we offer a fixed term contract instead so they don't have to offer guaranteed hours after the reference period? So say it was set for 12 weeks. I'm not sure that that is the solution that it might at first appear, because you're really talking about two different concepts. One is the level of hours that an employee is guaranteed during the time that they're working for you, and the other is the duration of the period for which they are working for you. So it's like the distinction between part-time and fixed term. So part-time and indeed 0 hours is about how many hours they get, whereas fixed term is just about the length of the contract itself. So I think you could definitely see a fixed term contract that would fall within the definition of the new regs as being 0 hours because it doesn't offer any guarantee of hours within the term. I suppose on the other side, if your fixed term contract contained a certain minimum level of guaranteed hours, taking it outside the scope of what's called a 0 hours contract or similar, then it would do the job. But the fact that it's fixed term doesn't help you either way. It's the nature of the hours rather than the duration of the contract. Michael, does that sound right to you? Just
Yes, I think
yeah,
so. Yeah,
okay.
yeah, I think so.
Another one on 0 hours. Any thoughts on the relative benefits moving forward from 0 hours versus casual contracts and the potential for the latter to be challenged? Well, it depends. I suppose it depends on the nature of the casual contract, because casual contract in itself isn't a term of art as far as employment law is concerned. You might have an individual who is engaged fully in the world of us being a self-employed contractor, one who is neither a worker nor an employee. But most individuals who engage on casual contracts usually fall at least within the definition of worker for the periods that they're working. So I think it's unlikely to be a useful situation to try to treat someone who falls within the definition of worker and would be classified as 0 hours and try to treat them as someone who's genuinely self-employed. I mean, there's been a large history over the past couple of decades of businesses and organizations falling foul of attempts to treat people as self-employed where they're not. And you know, you can go all the way back to the Auto Cleanse in Belcher case that went all the way to, I think it was the House of Lords then, rather than the Supreme Court. But you know, you look at that, look at all of the very complicated arrangements that have been made by various tech-driven taxi services and how those have gone wrong. So gone wrong for them, I should say. So you know, I think the important thing is identifying what you actually need and construing your contract to meet your requirements rather than doing something clever with the labeling of the contract. But I think the other point to make is the proposed changes to rules on 0 hours workers are drafted very widely and will catch you know, a wide net of potential circumstances, possibly even wider than that that's intended by those who've drafted the legislation. And it may be that some of that unintended consequence will come to light during the readings of the bill, and maybe we'll get some refinement to the current wording, or that will come during the consultation and we'll get some additional protections for employers in the scope of the regulations, but we'll have to wait and see.
I think, Bob, you're having to do much of the heavy lifting here, because there's another 0-hour question here, which is any thoughts
Yeah.
on how this will work for exam invigilators in secondary schools, where we use 0-hour contracts, as they can accept or refuse work when offered?
Yes, the reference period will be difficult. Well, that's true, but you can think of really an enormous range of sectors that do rely on very specific 0 hours arrangements. Schools, as you said, with exam invigilators. The same applies for higher education institutions that do the same, or quite commonly will use non-guaranteed hours arrangements with music tutors to come in as and when is convenient for the tutor. But the retail, leisure, hospitality, all rely hugely on what you might just generally call casual workers. And there's certainly, and I think this is well reported, huge raft of individuals who benefit greatly from being able to pick up hours as and when to suit their lifestyles and their other commitments, whether that be multiple jobs or students are an obvious example. So I'm afraid that the person who's asked the question, how will it work for exam invigilators where it's difficult to define a reference period? I don't know how it's going to work. I don't have a prediction to offer you. I agree that defining the reference period will be difficult. And I think that when it comes to actually setting out the regulations to define reference periods for 0 hours contracts, the people who are going to create the secondary legislation have got a real difficult task ahead of them. I'm sorry, I can't be any more positive than that. I think the next question's already been answered, Michael, so we can skip over that.
Yeah.
Next one's for you.
The next one is relating to probationary periods. We do not use, the questioner says, we do not use for teaching staff, but do for support staff. Head teachers feel that probation periods would impact recruitment and does not want included in contracts. Also, any thoughts on how trade unions see this issue? Well, I think that question highlights an interesting point that we don't know the answer to, is how far the statutory probationary period, or the initial period of employment as it's called, will need to be reflected in contracts of employment. So if you have a contract which has no or a different probationary period, will that impact upon the statutory protections? Remember, the statutory protection is to allow employers to have a lighter touch process, potentially with a more restricted compensation regime, to remove people for specific reasons where they're not right for the job. So I suspect that statutory provision will exist for people whether or not they're reflected in the contracts of employment. And in terms of how the trade unions will see it, I'm sure the trade unions are generally in favour of the idea of unfair dismissal as a day one right. I don't know offhand what views they voiced about the idea of allowing some flexibility during the initial period of employment, whether that's 6 or 9 months. But that they will have their say, as everyone else will, during the period of consultation prior to the autumn of 2026. Looking on to the next one. The Conservative government's neonatal leave due to be brought in from April 2025. Is that still going to happen? Well, that's a good question, and one I can't automatically answer, Bob. I don't know about you.
Yeah, I don't know the answer specifically, but I do know that a statutory instrument is required in order to bring the provisions of the Neonatal Leave Act into force. So a positive step is going to have to be taken by the current government in order to implement. Don't think it's happened yet, but it's been a while since I've looked at it, so I'm not 100% able to answer that off the top of my head. My best guess is that as a positive step will be needed to take it, and it hasn't happened, so we don't know whether or not they're planning to do it. So we can't be sure that it will come into force, because it's not the status quo. If it's just left alone, it won't come into force. They've got to do something to think about it. So there's a chance that they'll decide it's not something that they wish to implement. But I don't
We
know
can
either way.
certainly look into that and
Yeah.
follow up. If the questioner, I think, is anonymous at the moment, if they make themselves known in the Q&A or whatever, we can follow up on that for you. The next question is for the sexual harassment legislation in HEI, that's higher education institutions. Will it be applied also to students if they raise any grievance against a faculty member?
I think the answer to that is no. Well, a student who raises a grievance against a faculty member can engage the duty to prevent harassment. So if a student says they've been harassed by a faculty member, then the question of whether, assuming the legislation has come into force, the university has taken all reasonable steps to prevent that harassment does become engaged, because it applies to any third party. So it can apply to a student in the same way that it applies to any a consultant, a client, a customer, in other organizations. So to that extent, a student complaint would be relevant. But in terms of how the student's complaint will be dealt with, that's really going to be a matter for the Office for Students Condition E6 guidance on handling student harassment complaints. So what we see at the moment, where you have such situations, is there is the HR and employment side of things, where you need to properly investigate the allegation against a member of staff, and then there's the student regulatory side of things, where you need to properly deal with the student's complaints. So you'll have two areas engaged at the same time. The next question is, do you have any recommendations for exam invigilator contracts? We typically hire on a permanent casual 0 hours contracts, but they are only needed for specific weeks in a year. I think my recommendation is don't do anything yet, because we have so little detail. Be aware that you may need to make quite significant changes to your current arrangements. Neither Michael nor I work with schools significantly as part of our normal day-to-day work, but I'm sure our schools team are already thinking about the kind of changes that are going to need to be made, because obviously this is an issue that affects the whole sector, as those kinds of practices are fairly widespread. But I think really at the moment, we just have so little detail that starting to try and change things before we know what the regulations themselves are going to say is going to be a bit premature.
So the next question is a request for us to send a link to EHRC steps, technical guidance and government timetables. We can certainly send links to the next steps document and other supportive documents that the government's issued around the bill, if that would be helpful. And I can see the name in there, so we can send that on as an email attachment if anyone else would like those.
I think I wrote a blog for our university clients about the reasonable steps to prevent sexual harassment, so the 26th of October change, and that's got links to the EHRC guidance and the 8 steps guide. So if you find my blog, you'll find the links.
That may be the way to deal with it. And yeah, where do people find your blog, Bob?
On the VWB website, Michael.
Excellent, excellent. Okay. And the next question is, when do you expect the new legislation around group consultations across multiple sites to be in effect?
Yeah, I think that's essentially the same answer. We think it's probably going to be towards the back end of 2026.
The next one is, what would you advise as adjustments to raise awareness among employees to avoid, in a possible tribunal, the additional fee for sexual harassment?
I think first of all, I would say that given the threshold, it's quite difficult to envisage a circumstance where an employee succeeds in a tribunal claim for sexual harassment, passes that threshold, and then an employer is able to satisfy the tribunal that it has, despite the act of harassment having the claim for harassment having succeeded, it nevertheless did take reasonable steps to prevent it. I mean, obviously, as a minimum, you're going to need to comply with the recommendations of the HRC. And I think what I would say is, rather than trying to take you through the specifics of adjustments to raise awareness amongst employees, I would say have a look at the HRC's guidance, because it does provide some detail as to the nature of consultations and trainings with employees that you should be undertaking. Otherwise, it's probably a longer answer than we've got time for.
There's a couple of questions around
Shall we,
timing, which I think
shall we skip over any other questions about when things come into effect, Michael? Because I think it's the same answer each time.
And there's a quite a detailed question, which I think is very specific and seems a very valid question, but I think probably it's very specific to someone's workplace. So we'll probably give that one a miss, but please do get in touch with us separately. And I'm sure someone in the employment team will be able to go forward with that.
Yes, the person who's asked about the holiday club, that looks very specific and quite detailed. I would say, as Michael says, get in touch with the person that you normally speak to at VWV, and we'll try and answer that in the detail that it needs.
So one after that is, if harassment is covered under the grievance policy, would that suffice, or do we need to have a separate anti-harassment policy? Well, I think the answer probably is to have a separate policy going forward, because there's the requirement to show you've taken all steps, and the separate policy is going to be part and parcel of that, along with a lot of other things. Bob, I don't know if you've got anything to add.
Yeah, no, I completely agree. I don't think it's going to be sufficient to merely mention harassment within the grievance policy. I do think you're going to need a separate policy setting out how you treat complaints of harassment in particular, in order to meet the requirements of even the current guidance on sexual harassment. But you also, if it comes into force as proposed, the new duty to prevent harassment is specifically going to apply to acts of harassment against your employees by third parties, which I wouldn't expect a grievance process to cover at the moment. So you'll need something to specifically address that in any event. And I think even as the law currently stands, it makes sense to have a separate policy dealing with harassment issues, particularly regarding the sexual harassment prevent duty.
The next question comes at the same thing from a different angle, which talks about, in the disciplinary procedure covering harassment as gross misconduct, do you need to have a separate anti-harassment policy? I think our answer is yes, you do need a separate anti-harassment policy, but of course, including harassment as gross misconduct is probably another useful thing to have. So there'll be touch points within the disciplinary policy, as well as in the making that clear within the harassment policy itself.
So the next question is another 0 hours one. If you offer a set amount of hours in a reference period, does the worker have to accept the hours? No, the answer is no. So this is it's made clear actually in the legislation that the worker is under no obligation to accept the guaranteed hours offered. So thank you for that. That's a helpful point to clarify. The next one is about, can you remind of the duty in relation to preventing sexual harassment of staff if staff meet up outside work for activities not officially organised? Excuse me.
Well, there are plenty of cases, aren't there, where sexual harassment has arisen out of non-work functions or functions outside of work. There will always be a case-by-case analysis.
Yes.
And some things will be genuinely separate from work, and other things will be in that middle zone between work and private life, and that middle zone has caused problems in the past.
Yeah, I think that the term that the tribunals have come to use from following a couple of appellate cases is whether there is sufficient connection between the outside activity and work, and that's a matter of fact and degree. And as Michael says, some organisations have fallen foul of that, and even though it's not been officially organised, there has been held to be a sufficient connection. So it's one of those grey areas where your specific circumstances are going to make the difference. But if you are thinking about sort of the practical implications of dealing with it, I would say certainly your policies and your training should contain guidance to employees about appropriate conduct in events involving work colleagues, whether inside or outside the workplace.
Yeah, I'm sure Bob's the same, but we do get relatively common questions, which usually are around there has been an event organised by work, and then people go on to the pub. Senior management might go home, and issues unfold at that stage. That's quite a common situation, and probably one, I think, which would normally probably fall within the remit of the employer's problem.
Yeah, I'm trying to remember. I think there was a case that a reported case that was on exactly those lines, wasn't there? Where
it was, yeah.
So I think you're right, Michael.
So we've got a couple of minutes left, and we've got a couple of questions more. Next one is, our current contractual probation period is 12 months, 3 terms for teachers. Can we retain this, or will 9 months be the maximum probationary period? No, I don't think there's any suggestion that 9 months will be the maximum probationary period. As I say, I think the 9-month period is the period that government currently envisages would be useful for the initial period of employment, during which you can take advantage of the lighter touch regime around dismissal. That doesn't preclude you from having a different probationary period in your own contract, and your own contractual probationary period allows you an opportunity to assess whether or not the individual is right for the job. And if you have the right evidence and you follow the right procedure, such a dismissal may well be fair under the general rules of unfair dismissal if it falls outside the light touch procedure, for example, because it's gone on too long. Obviously, schools have a particular regime. Employers more generally might want to think about bringing probationary periods into line with the statutory periods to ensure that you think about things at the right time.
Or I suppose the other key aspect of a probationary period, apart from it being intended to be used to assess an employee's suitability, is that it also tends to come with a shorter notice period than is triggered once employees have successfully passed probation, and sometimes the increase can be relatively significant from probationary notice to non-probationary notice. And so, you might continue to operate a period of probation that's longer than the proposed initial period of 9 months in order to retain the benefit of that shorter notice period. But you're going to have to be well versed both within the HR department and management of the need to adjust the procedure once you fall outside the new initial period. I know that in universities, very long probation periods are quite common, and we often see for permanent academic staff something like a 2-year probation period.
Well, that keys into the next question, where somebody says, do we need to change our probationary periods, which are currently up to 3 years?
Yeah, so, I suspect that's someone from a university.
Yeah. And obviously changing that period is not that easy, because it's probably something which would have to go through a staff side structure of some sort, union.
Yes.
So subject to that, a 3-year probationary period has its downsides and upsides anyway, no matter what the changes in the law say. But you might want to think about how you look at performance or capability during the initial period of employment currently envisaged for 9 months, because you need to think about that. If you think about it at the end of the 3 years, you've just got your normal unfair dismissal rights, which will be applying then. So you might want to think about things a little earlier. The next question is, the changes in fire and rehire, whilst intending to curtail the worst successes, are likely to mean some unions will have carte blanche to block productivity changes. Well, yes, and I think that point sort of encapsulates some of the debate here. The government is obviously intending to stop what it considers unscrupulous behaviour, and nobody, well, very few people would side with P&O Ferries, for example, in relation to what they did. But then again, the legislation needs to be put in a way that it doesn't stop what might be seen as changes necessary to enhance or to remove outdated work practices or to increase productivity necessarily. So it'll be interesting to see how that will be shaped through the consultation process. At the moment, the way the draft bill is prepared has very wide-ranging implications because it's very robustly drafted, really, and could impact on a wide range of things. I think we're pretty much at the end.
Yeah, we've got a couple of questions that we've not got to yet, but I think,
Yeah.
as you say, we're 1 minute away from running out of time.
So I think we'll probably have to draw to a close there. But thank you so much for your questions and for the engagement. It's really helpful for us to see what's concerning you. And I hope that the talk generally has been helpful and that you all have a wonderful day. Thank you
Thanks
very
very
much.
much, everyone.